whatever.
Third, Mr. N. Ahmed, counsel for
I'm 75 days already behind them. Let it be on 8 of 8
8th of
Yes, sir.
September.
Hello.
Item 2,
Made please, lordship. 439 application, my lord. Allegation, my lord, under section 489A, 489C, lordship. CD may be all from
Third, Mr. S.
R. Islam.
R. Islam. Applicant.
From Hatigao, on 14th Feb.
40.
Obliged.
item 48 of the supplementary.
May I please, Your Lordship? Lord, this is 439 applicant. The allegation is
What
under
is the offense?
436 IPC.
Case diary would be required.
Charge sheet has been filed.
Charge sheet has been
Charge-
filed and my lord, the trial has also commenced.
Okay. Since when you are behind the bar?
Arrested on my lord 10 to 2023. So as on date, my lord, more than 290 days I am behind the bar.
How many?
My lord, since 10 to 2023.
How many days?
My lord, it is more than 293 days.
And what is the stage of trial?
This is appearance.
Appearance
Appearance, my
stage.
lord, the charge has been framed, my lord, and that the case is not pending
For evidence.
for evidence. But the fact is that, my lord, on the several occasions, the case has been posted for evidence, my lord. But the no witness turned up, and therefore
When the charges were
charges were framed, my lord, your lordship will find at page number 36. Page number 36 on 20th of May 2023, charges were framed, my lord, whereby I pleaded not guilty and claimed to be tried. And since then, my lord, several dates have been fixed for evidence, but no witness turned, and therefore the trial could not progress.
where is the FIR?
FIR, your lordship will find at page number 12. Mary.
Yes.
Lordship, let us call for the status report at what stage the trial proceeding is going.
My humble service to be, my lord.
No, the charges are not
Already.
you earn the hotel.
These charges might be there, my lord. Even if that, my lord, the allegations that I have committed the offense, I am ready to face the trial, my lord. And that I
Otherwise-
have produced all the certified copies of the orders of the lawyer.
Where is the rejection order of trial? court?
Rejection order, my lord, your lordship will find at page number 42.
42, Lordship.
The trial court had not gone into any of the merit or demerits of the case, but simply saying that the nature of the offense is grave. Therefore, Lord, my bail prayer came to be taken. But that cannot be the justified ground, as your lordship knows. Only gravity of the nature of the offense cannot be the ground to reject one's petition, my lord, unless until and unless so, my lord, other material shows that I was involved in the matter.
By the way, from the FIR itself, the prima facie case is made
This
out,
is the case of the other side.
and Lordship
It's not,
already
it's not
charges
the
has been
actual
framed.
projection of the case.
Let me call for the status
Case
report.
diary. What are the evidences against you?
Lordship,
Because, my lord,
that is required.
Let us call for this. Yeah, okay.
it is up to your lord.
Third, Mr. S. Islam, the counsel for etc. As the said case, petitioner has denied bail in spite of the fact that charge sheet has already failed. The perusal of the scan copy of the case record of sessions case 64/23 put CSA for consideration of respective. Hence, call for the scan copy of the case record of sessions case number 64/23 of the Court of Thane Additional Session Judge for 5
Kamrup Metro.
Kamrup Metro, along with the case diary of courts of PS case number 22/23.
A short date में kindly
Let this case be displayed again on
Through registry, it may call.
20. Can I shorten it? 18.
मिले.
For motion, item 3.
May I plead the lordship? Lordship, for 82 RPC application lordship for affair passing lordship. The affair is for lordship. Fourteen lordship. 70. I read lordship. We do respect lordship 73.
What is the allegation?
Allegation 306 and 34.
326.
Yes.
306.
30.
30.
Page 17, the affair lordship.
What is your name?
Lordship,
Mukku.
Muminur Islam
Mominur Islam
and
Mominur.
petitioner
and two others. Sir.
and two others. Yes, Lordship.
What is the ground for?
Yes, Lordship. And after investigation of the police, Lordship, Tasik submitted, Lordship,
Dash
with
it.
25 years, Lordship. In this, Lordship, the last part, Lordship, 25 years.
Yeah.
With the 38 of the translation copy, Lordship, during it is reveals that the
Page number?
page 38 reveals that I read, Lordship.
Second period.
Second paragraph. Disease Profikul Islam has written a suicide note before the committed suicide, and the same was handed over the police by the family members and labor Bharakjyoti Nath of the tenant of the Disease Profikul Islam stated long ago in the past Disease Profikul Islam had a affair with someone. As per the suicide note, the accused Mominur Islam Mukul Ali Afzalur Rahman, Shah Kamal Sikdar Sarkar, and Shahjahan Sarkar knew the matter. The accused also had the full details of his mobile and threatened to viral the same of for which he suffered mental tension, and probably due to tension of the disease, Profikul Islam committed suicide on 18/5/2023, Lordship. It is the allegation, Lordship. And suddenly, Lordship, the suicide note was viral before, Lordship, in the social medias, and I collected this. Don't know annex this, Lordship, and it is stated that 20 years back this incident, Lordship. And
No,
Lordship,
on what ground you are telling the document? At what stage it is been?
yes, Lordship. And I also, Lordship, mentioned in the ground, Lordship, 6, Lordship.
Have you appeared before trial court?
Yes, Lordship, I appeared, Lordship, the Today, it's 7 of 12 lordship. It is the for consideration of tax lordship. In the meantime, your lordship call for the records and lordship
LCM may
notice
be
to
called
the
for
respondent
scan copy.
and issue to the respondent.
Heard Mr. M. Rana, Senate Council for Petition. Also heard Ms. S. H. Gora, Senate Additional Public Prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed, praying for quashing of the FIR as well as charge sheet number 72/2023, dated 39/2023. What is the PRC case number or sessions case number? Stop. Issue notice to the response.
Lordship, PRC case number 514/23.
Sessions case number
And no lordship, it is not session case number, GR number lordship 377/23.
PRC case number
PRC case number 514/23
pending in which court?
in lordship Chief Judicial Magistrate.
Issue notice to the respondents and call for the scanned copy of the case record of PRC case number 514/2023 from the Court of Learned Chief Judicial Magistrate,
Okay.
Pokhara, Jharkhand, as well as the scanned copy of the case diary of Pakiragram PS case number 55/20. As learned additional chief judicial, as learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to the respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after court.
Public.
Item 4,
May I please? This is the petition for the Jilma of the 62,000 bottles of cough syrup. And the trial court rejected my prayer of the Jilma matter by the order dated 7/11/23. In this case, the petitioner is the owner of a drug distributor, AK drug distributor. He has purchased it from Kolkata by all the valid documents. In the bail order of the Honorable High Court and the trial court also indicates that all the documents regarding the purchase and the GST are genuine. That has been already been reflected in the report of the concerned police station as well as the order of the High Court. All the documents regarding the purchase, it is genuine. GST has been paid.
Why it has been rejected? The
Jimma petition, my lord, now the charge sheet has been filed under 21(3) of the NDPS Act. In the meantime,
against you.
against all of the person, my lord, including me.
Okay.
Then we filed the Jimma matter. In a peculiar ground, the Jimma has been rejected, which has not been, so that particular
No,
section,
the charge sheet has been filed. The contraband is this material.
in spite of the fact that the whatever, but the rejection order is very peculiar. The charge sheet, there is no allegation of violation of the Tax and Cosmetic Act. There is no section also included in such. Now the learned trial court, by rejecting the application matter, incorporated in the order that there is a violation of the Tax and Cosmetic Act because these contraband, alleged contraband, it has to be sold in the western region, not in the eastern region. But in the charge sheet, no section under the Tax and Cosmetic Act. added. But in spite of that, there's a,
In charge sheet, drugs and cosmetic act,
there's no. It has not been filed under the Drugs and Cosmetic Act. It's a simply 21C of the NDPS. But whereas while granting the bail, this court as well as trial court and all the documents appears to be genuine
but
regarding the
in
party.
spite of that, charge sheet has been laid
In
against.
spite of that, madam, the charge sheet has been laid, but that's a different issue. But the rejection of the order no way connected to the sections of the NDPS case, rather he has gone into the effect that there are violation of the Drugs and Cosmetic Act, where the punishment prescribed is 1 year. If there is a rule has been violated, and there can be a suspension of the license. On that ground, on that strict, my petition was rejected. Another question is involved here is that all the articles there's an expiry. So it's going to be expired in 2024. December 2024. There's only 1 way remaining in between. So what we can suggest also that if in spite of they don't give the Jimma, they can add telling it to that or pursuing receiver, they can keep the money at present till the end of it. So that is our alternate thing because so that nobody suffers. Tomorrow I am acquitted. So that if the property got damaged, then there's no recovery. So it will be very difficult. And the other hand also,
Otherwise, also contraband has to be disposed of.
yes,
Yeah.
because
Is
of if it isn't found to be the contraband is a illegally manufactured. But as far as the report of the under the NDPS contraband is that what you can see in the page 26 High Court order, very specific. Page 26, the High Court order, bail order. Page 26. First, the investigating officer has got the documents verified from the competent authority and found to be valid as per the provisions of the Assam Goods and Service Act 2017. Then the learned Court of Special Judge MDPS Dhubri in the order dated 20, recorded as per the report of the Assistant Commissioner of Taxes Dhubri dated 20, the invoices of email payment bill and verified and found to be valid. So, in spite of that, the charge sheet has been filed. So I have license my lord. I can procure the things.
Where is the rejection order?
Rejection order, Lord, you will find at page 187. My lord. 11 portion start subsequently. This is the order, my lord, and the 11 portion was you will find 189T, my lord. Paragraph 7. Peruse the office order dated 11/6/21. As per the state order, quantity is to be supplied per month to the wholesalers, stipulated as 22,000 bottles per month. However, in the instant case, total 62,000 numbers of extra cough syrup are seized by the police. Therefore, such transportation of the seized codeine-based cough syrup is made in the contravention of the office order dated 11/6/21. That 11/6/21 that has been issued under the Drugs and Cosmetic Act. Page 193. Last page, my lord. Lord, you can see second last page, I'm sorry, ma'am. 193.
193 is the
Office order, my lord. That is the referred by the trial court, by virtue of which my prayer has been rejected. The violation of this office order.
what it says. It says how much quantity can be kept in
They state, my lord, the codeine-based cough syrup, only 200 bottles can be per
2000.
month, 2000 bottles per month. But in this case, my lord, 64,000, 62,000 been transported. That's the violation as per the. So it is basically, this is the under the Drugs and Cosmetics Act. And punishment prescribed is 1 year. And maybe suspension of license for a period. As per the section 27C of the Drugs and Cosmetics Act. And rule.
Now,
The notice may not be published. You know, in the meantime, it take the response from the IO or what my learned can suggest.
now you have alternative prayer.
Sir.
Alternative prayer. One query is that this is the contraband in an NDPS case. So there may be difficulty in handing over the same to the accused, even if you have a good case. You are accused in that.
Yes, I'm.
Your alternative prayer that this may be disposed of pending trial, so
Yes.
that if
And the
ultimately
disposing of and the money
can be kept
proceeds,
in treasury.
yes. So that till the end of the trial. That's my alternative.
If it has not yet.
Yeah.
Otherwise, in the meantime, disposed of already.
Not dispose of my children. But it's my intent.
So you seek instruction
Lordship,
from the,
yes. Whether this seized contraband bottles has been, Lordship, it's a subject matter of investigation or not. We'll-
no,
Yeah, already
no,
subject.
it is the subject matter.
Yes,
And has been already been subject.
yes.
Where it is lying now,
Now it's in Gulukan Circuit.
where it is kept,
Yes,
and whether it has been disposed of or not.
because the planet section court would definitely know that because it could be
Because
disposed of.
there is a mandate also within a specific period of
Yes.
time.
So the IO, from the IO, they can.
A report may be called.
Report
Yes,
may be
report
called
may be
whether it has been disposed of by
Lordship,
virtue of an order and whether it can be disposed of by selling those articles.
Okay.
Lordship.
Mr. A.M. Bora, the senior counsel, assisted by Mr.
P.A. Chaudhary.
V.A. Chaudhary, learned counsel for the petition. Also heard Ms. S.H. Bora, learned petitioner public prosecutor. This application under section 482 of the Code of Criminal Procedure, comma 19, read with section 457 of the Code of Criminal Procedure 1973, has been filed by the petitioner Abdul Kalam Laskar.
Woman of the-
Abdul Kalam Laskar, praying for releasing 388 cartons of 388 cartons consisting of 62,080 bottles of S-cup cough syrup, which were seized during investigation of Golokganj PS case number 13/2022 by the investigating authority. Learned counsel for the petitioner has submitted that in after completion of the investigation of Golokganj PS case number 13/23, charge sheet has been laid against how many accused persons?
Three.
Three accused persons, including the present petitioner.
Under 21 scheme.
Under section 21C of the NDPS
NDPS.
Act, showing the 62, showing the seized bottles of the cough syrup as the contraband in the instant case. Learned counsel for the petitioner has also submitted that the petitioner had all the valid documents regarding transportation of the contrabands which were seized in connection with of the instant case. And in that regard, learned senior counsel for the petitioner has also referred to an observation passed by a coordinate bench of this court in bail application number 1232/23 dated 25/5/2023, in which a prima facie satisfaction was expressed by this court as regards the validity of document in respect of the seized contraband. Learned senior counsel for the petitioner has also submitted that though the charge sheet has been laid against the present petitioner only under the provisions of NDPS Act, however, the Jimma petition filed by the present petitioner seeking Jimma of the seized contraband was rejected by learned trial court on the basis of an observation that there is contravention of the provisions of Drugs and Cosmetic Act 1940. Stop. Senior counsel for the petitioner has also submitted that as there is a fair chance of the petitioner getting an order of acquittal in the trial, and as there is an expiry date of the seized contraband, he makes an alternative prayer that during the pendency of the trial against the present petitioner, the seized contraband may be sold and the proceed of the sale may be kept in treasury, which so that in the event of petitioner getting an order of acquittal, he may not suffer a loss. Considering the submissions made by the issue notice to the only state is the
Yes.
also heard learned additional public prosecutor. Considering the submission of learned counsel for the petitioner, the additional public prosecutor is requested to obtain a report from the investigating officer as regards the status of the seized contraband and his response regarding the prayer of disposing of the contraband by selling the same and keeping the proceeding in treasury during the pendency. When the report may be got.
Lordship, can it be on 18/12?
Let this case be listed again on 18.
Public.
Lordship, a copy of the order may be transferred.
Before somewhere right issue. No formal notice need to be responded as not an additional public prosecutor has already appeared for this purpose. Let a copy of this order be furnished to the learned additional public prosecutor.
Okay.
Item 5,
By this decision, my lord, that challenge the proceeding of a PSC case pending before the JMFC. Lord, here in this case, my lord, after at page 13, allegation of kidnapping of minor daughter of the informant. That is the response number 2.
Page, FIR is at page 13.
Page 13.
Yes, charge sheet has been laid in this case.
My lord.
At what stage the trial is been
At the very initial stage of appearance.
appearance? You have appeared.
No, my lord, in this case, my lord, she was not minor. The victim was not minor at the time of occurrence. In fact, my lord, the petitioner and the victim, they willingly went away out of love affair and they got married in the year 2017, your lordship. And since then, they have been passing their days peacefully, your lordship, as husband and wife. My lord, out of their wedlock, one female
are-
child is born. I have annexed the birth certificate of minor child, your lordship.
The victim is your wife.
My lord.
We are issuing notice, let her appear.
Yes, Lord.
In the meantime, my lord, proceeding may kindly be stayed.
No,
Let them appear.
let her appear.
Page 24 may kindly be. And
When is the next date fixed?
in the month of January.
We will fix date before that.
Okay.
When is the exact date?
I could not collect the
Heard-
exact date, my lord,
heard
but in the
Mr.
month of January.
Heard Mr. A. Rahman, the counsel for the petition. Also heard this SH for the litigation. This application under section 482 of the Code of Criminal Procedure for read with Article 227 of the Constitution of India has been filed by the petitioner Abdul Qayyum Pradhani, praying for quashing of the charge sheet number 114/2022 dated 28/2/2022, as well as the consequent proceeding of PRC case number 1016/2022 pending in the court of learned judicial magistrate first class. Who is petitioner number 2?
There is only one petition.
Only
No,
one petition.
respondent number 2.
Respondent number 2 is the informant.
Who is the informant?
Informant is the father of the victim.
Father of the
Father of the respondent number 3.
issue notice to the respondent. As learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, 2 and 3 are concerned, learned the petitioner shall take steps for issuance of notices on the respondent number 2 and 3 by registered post with AD within 3 days from the date of this order, returnable after 3 weeks. First week of January. Let this case be decided on 4th of May. The prayer for interim relief would be considered after the service of notice on the respondent number.
Must of it.
Item 6.
May I please, your lordship? 438 application, lordship, this is a second bail application earlier rejected by your lordship, which is at page number 20, annexure 3, lordship. Sorry, annexure 2, lordship. Lordship, new ground for filing this petition is the page number 23. Another person which is also involved in this case but not named in the FIR, as in this petition, petitioner number 1 is also not named in the FIR. he is granted anticipatory interim protection, Lordship, and case is fixed on Lordship 17.
17. Next date.
Now, what has happened to that?
Lordship,
Finally,
we may be given a chance, Lordship, will appear before the IO, Lordship.
no,
Up to
no,
the
no,
case
that-
date.
that
City
is
will be
not the issue. Issue
Yes,
is
Lordship.
once your prayer for anticipatory bail is rejected,
Yes.
there must be some ground. What are those grounds to consider your subsequent? And what has happened to this co-accused? What is the final order? If you can procure the final order of the co-accused, it may help you. In the meanwhile, we may call for the.
After some time,
After
Lordship,
some time.
after some time.
Yes.
I have to verify it.
Okay.
After some time.
Item 7,
Here, please, Lord. But in this case, my lord, I am, my lord, on behalf of Mr. Zaman, my lord, who is out of station, my lord. Here, my lord, the FIR, my lord, case 11. Case 12, my lord. Case 12, my lord. Charles Major, my lord. He eloped with the petitioner. They are in love affair, my lord. Now they have married, my lord. And he earlier approached this small court. This small court, my lord, passed an interim order, case 14.
Then what happened?
My lord, my lord, order was not communicated, my lord, due to some communication gap with the council, my lord, and he could not appear before the IO within 7 days. So interim order was recalled. In subsequent date, my lord, Anglican advocate remained absent. So it was dispute for default. Interim order may be protected, my lord. I'm
Police is again searching you.
lost. So I will appear, my lord, within reasonable time.
Case diary would be required.
Yes, Lordship. Otherwise, there is a violation of court
Uh,
order.
No, for that he was not given benefit of,
Lordship.
he did not
City will be required.
heard Mr. A.
Orally.
R. Ali, and counsel for the petition. Also heard Ms. S. H. Moran and the additional of this application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Jahir Hussain, who is apprehending his arrest in connection with Kheroni PS case number 32/2023. The gist of accusation against the present petitioner in this case is that on 26/3/2023, one Shri Prem Bahadur Chetri had lodged an FIR before the officer in charge of Kheroni police station, inter alia, alleging that on 23/3/2023, the present petitioner had kidnapped the daughter of the first informant and took her to Kerala. Stop. Learned counsel for the petitioner has submitted that petitioner and the victim were having a love affair, and later on they got married to each other. And where she is staying now?
With me, my lord.
And presently the victim is staying with the petitioner as his wife. It is also submitted by learned counsel for the petitioner that earlier also the present petitioner had approached this court by filing an anticipatory bail application, which was registered as AB 1584/2023, wherein the petitioner was allowed to go on interim bail on the condition that he would appear before the investigating officer within 7 days of the grant of the within 7 days from the date of the said order. However, it is submitted by learned counsel for the petitioner that due to communication gap, the petitioner defaulted in appearing before the learned before the investigating officer on that occasion. And thereafter, when the said anticipatory bail application was called for hearing, the engaged counsel defaulted in appearing before the court, and therefore the earlier anticipatory bail application was dismissed for default. Learned counsel for the petitioner submits that he is ready to cooperate with the investigation in the investigation. On the other hand, learned petitioner submits that perusal of the case diary would be necessary for consideration. Hence, call for the case diary. So, in the meanwhile, considering the submissions made by learned counsel for the petition and considering the fact that earlier this petitioner was allowed to go on interim anticipatory bail. However, he defaulted due to communication gap with the engaged counsel, and at present he is ready to cooperate in the investigation. He within bracket petitioner Mohammed Jahir Hussain is hereby directed to appear before investigating officer of Khaironi PS case number 32/23 within a period of 10 days from the date of this order, and if he does so within the stipulated period of time, in the event of his arrest in connection with Khaironi PS case number 32/23, he shall be allowed to go on interim anticipatory bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Let this case be listed again on
2112.
21/12 for case.
Typing 6.
Lordship, I have received the order, final order.
But his case may be different from your case.
Might be on a different
Similarly
case.
situated person, he is also not named in the FI. So far as petitioner number 1 in my petition, he is also not named. We are in the same footing, Lord. Lordship, we are trying, Lordship, we may be protected and up the city may be followed. If there is anything found, outright it may be rejected.
Lordship, although it was rejected, since.
No, we have to peruse.
Yes,
that,
CDB
because
period.
once it was rejected.
Yes,
So unless we peruse the case diary,
Yes.
we will peruse the case diary.
He
Then
will
we,
protect.
no protection.
Because I am also similarly situated person. Lordship.
let us
No.
see whether you are similarly situated.
Yes,
or not.
Lordship.
Let
That's
us-
true.
Let us verify it from the case diary. Heard Mr.
G. Somo.
G. Samua, learned counsel for the petitioner, also heard Ms. S.H. Bora, learned petitioner for project. Considering the fact that the petitioners are appearing before this court for the second time after their prayer for anticipatory bail was rejected on an earlier occasion, perusal of the case diary would be necessary for the consideration of the instant bail application. Hence, call for the case diary. Fixing
Lordship on 1812.
18/12 for case.
Obliged, Lord.
Item 8.
The 438 application 5 petitioner before lottery medal. Petition number 1 is the name accused, 2, 3, 4, 5 they are not named. In fact, rivalry of 2 group medal, physical assault, 2 FIR laws medal, At the first instance, we lost the FIR. Second, the rival group lost the FIR. Madam. Against this second FIR lost by the rival group, I am here before your lordship, taking anticipatory bail. Madam.
Where is that FIR? At page?
Page 13 is the FIR.
FIR against you.
Yes, page 13.
What are the injuries caused?
Injuries, my lord.
What is alleged?
Yes, my lord.
Grievous.
Previously, initially it was registered under 325, subsequently 328. In
Yes,
the
sir.
City,
other
city
case,
allows
my
the
lord,
inquiry
same
report to be prepared.
nature of allegation, my lord. This honorable court, my lord, your lordship will find at page 24. They came before this honorable court, lordship, page 24. My lord. They have been protected. This case was subsequently registered, my lord. We registered. Our case was registered at Julius and PS case number 167, my lord. Against which, my lord, they came before this honorable court, my lord. By order at 9-8, they have been protected. Their case was subsequently registered. Similar nature of injuries, my lord.
No, those who are not named in the FIR, why
No.
they are apprehended?
My lord, your lordship will find the second FIR lost by us, my lord. Because,
Oh, no. There are 5 petitioners.
my lord,
Only one is the name.
My
One
lord.
is named in the
my
FIR.
lord.
Why others are apprehended?
Apprehend.
That is reflected in page 23, the FIR lost by us. All of them injured, both the parties.
No, that is not.
Since we are concerned in
Admittedly,
respect of
they were involved in
the
the
present
assault,
case
my lord.
also, city will be required.
All of them injured. Page
No.
23, your lordship will find.
You FIR against you is at page
Page 13.
13.
13.
Yes,
Who has been named in that FIR?
That petition number 1, Malik Doom.
Only Malik Doom has
Yes.
been named.
Yes.
Then why others are apprehended?
That time stated, my lord, page 23, may kindly be taken.
Page 23.
Yes, my lord. Admittedly, all are involved in the incident. The petitioner number 2 to 5, they also injured in the incident. Admittedly, all of them were there.
And police is searching.
Some protection will cooperate with the investigation. my lord. Let the injury report and CD come. Till then, we may be protected. Similar
What
nature of
is the
injury.
injury? We do not know. What
Well,
injury?
Yes, my lord. Only I can state at this moment similar injuries, my lord. All of them, my lord. Both the rival group. my lord.
Similar injury. We may protect other 4.
Yes, my
Lordship.
lord.
The named accused only after perusal.
Lord.
Heard Mr. Yes, Mr. P. Hajorika, the net counsel for the petitioner. Also heard Ms. S.H. Bora, the net additional prosecutor. This application under section 438 of the Code of Criminal Procedure has been filed by 5 petitioners, namely 1, 2, 3, 5, who are apprehending their arrest in connection with Ruliajan PS case number 168/2023 under section 341/325/34/506 of the 325/326/34/506 of the Indian Code. The gist of accusation against it in this case is that on 7/7/2023, one Jyoti Doom lodged an FIR before the officer in charge of Duliajan Police Station, Intermedia, alleging that on 2/7/2023, the petitioner number 1 had some argument with the first informant, and thereafter on 3rd of July 2023, the petitioner number 1 accompanied by his family members and relatives, attacked the first informant and his family members and caused grievous injuries on their person. Learned counsel for the petitioner has submitted that why the altercation happened.
While in the ceremony took place in the in-laws house of the petitioner number one. Some argument is
that there was some altercation between the petitioners and the informant's family over what matter?
that is not narrated, but some altercation.
Altercation and in which was followed by the assault of the petitioner by the family members of first informant. And in this regard, the petitioner, where is the FIR against filed by you?
At page 23 million,
And in this regard, who is Malik Dum?
Malik Dum is the petitioner number one. In this
The
case,
present petitioner had also lodged an FIR against the informant and the family member of the first informant on 7/7/2023 itself. It is further submitted by the learned counsel for the petitioner that in that incident, all the other petitioners, namely petitioner number 2 to 5 of this case, also sustained injuries. It is also submitted by learned counsel for the petitioner that in the cross case filed by the present petitioner against the informant, Jyoti Dum and 4 other family members of
private.
the petition of the informant were already allowed to go on interim anticipatory bail by a coordinate bench of this court, AP case number 2663/2020. Learned counsel for the petitioner has submitted that the allegation made that the allegation made against petitioner number 1 in the FIR is not true, and the other petitioners, namely petitioner number 2 to 5, are not even named in the FIR. It is also submitted that these petitioners are ready to cooperate in this case. On the other hand, learned additional public prosecutor has submitted that as this case involves sustaining grievous injury by the injured person and the clear allegations are made against petitioner number 1, perusal of the case diary would be necessary. Hence, call for the case diary.
22,
Give it in
January, 1st of January,
first week of
5th of
5th of January. However, in the meanwhile, considering the fact that petitioner number 2 to 5 have not been named in the FIR and they are ready to cooperate in the trial, in the investigation, they namely named petitioner number 2, namely are hereby directed to appear before the investigating officer of Duliajan PS case number 168/2023 and cooperate in the investigation. If they do so within the stipulated period of time, within 10 days, if they do so within the stipulated period of time, in the event of their arrest in connection with Duliajan PS case number 168/2023, the above named petitioners shall be allowed to go on interim anticipatory bail of rupees 30,000 with 30,000 each with one surety of like amount. subject to the satisfaction of the test with following copy. Let this case be listed again on 4th of
Fifth,
5th
fifth
of
of
January.
January.
I'm a blade. Presumably that Lordship is that is not interim order, it's a final order against
Against the, I will make
Yes.
against the other side. I
my
will make
blade.
Item 9.
I please your lord. Lordship 430 the application lordship. Offense alleged lordship T12 and P14 of IPC. And FIR is in case 11 lordship. Particular. Transfer copy is in 8. May I read lordship?
yes.
Most respectful, I take to say my wife, Kano Begum was pregnant of 2 months. At present, I am a father of 3 children. It is very regretful to state that as I had 3 children, my wife, without my knowledge on 1/9/2023, went to kill fetus of 2 months old child inside the home and accordingly went to the pharmacy near to our house. The aforesaid accused of the pharmacy pretending to be doctor gave some tablets to my wife. My wife pleaded after consuming the tablet. When I asked my wife, she said the accused person had given the tablet. My wife was immediately admitted to Goramari Hospital, but the health condition of my wife deteriorated. She was referred to GMC Hospital, but the doctor declared my wife expired shortly. So sir, she willingly went to my pharmacy and asked for the medicine. There is no such intent from my side to kill her lordship. And P14 does not come into play on the lordship. There is no intent. She went to willingly went to my pharmacy lordship. As a pharmacist, she asked for the medicine, I have given the medicine.
No, but you have to give medicine on prescription.
Yes, sir.
Her lordship, she willingly went to my pharmacy lordship.
Yes. Ms. Bora.
Lordship, otherwise 313 and 340, 12 and 314, without any prescribed form of prescription, Lordship, he has given the tablet also. Perhaps voluntary causing a woman with child by miscarriage, that may not be attractive. It is conduct without having any prescription here.
No, otherwise also whether custodial intent.
Let him be on interim. Lordship.
Heard Mr.
Equally.
D. Kolita and counsel for the petitioner also heard Ms. S. for the petition. This application was 438 of the Court of 193 has been filed by the petitioner Lankeshwar Kolita, who is ending his arrest in connection with Koromari PS case number 75/23 of the 3-1-3-1-4 of the gist of accusation in this case that one Hassan Abi on 4/9 had lodged an FIR for the officer in charge of Koromari station. Former interim the wife of the first informant who was pregnant by 2 months went to intended to get her pregnancy aborted, went to a pharmacy, and that is the pharmacy of the present petitioner, and procured some tablets and the present petition, and it is also alleged that the present petitioner pretending himself to be a doctor gave of tablets to the wife of the first informant, as the result of which the, the pregnancy of the wife of the first informant got aborted. However, her health condition deteriorated and she was admitted in hospital. Ultimately, she died in the hospital. Learned counsel for the petitioner has submitted that the petitioner never intended to kill the wife of the first informant. And as you are a pharmacist,
Lordship.
who are you?
For-
You are pharmacist or work in a pharmacy or
Does he holding a license or?
do you? What is your statement? Who are you?
With that knowledge,
You
I.
don't know who are you.
Okay.
That. But whether this pharmacy belongs to you, otherwise you will have to satisfy.
Lordship, kindly turn to page 4, paragraph 5. The petitioner begs to state that the petitioner is a practitioner of alternative medicine.
Oh, you are a practitioner of alternative.
Alternative.
Additional PP is helping you. You are not ready. You are not prepared. The petitioner submits that the counsel for the petitioner submits that the present petitioner is a practitioner of alternative medicine and he had given the medicine to the wife of the petitioner as asked by her, and other allegations leveled against the present petitioner in the FIR are not true. It is also submitted by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation. On the other hand, an additional topic was submitted that the perusal of the case diary would be necessary, considering nature of allegations leveled against this case. Hence, call for the case diary
Lordship 051.
fixing 5th of January. In the meanwhile, considering the submissions made by the counsel for the petitioner, as well as considering
It
the
will
facts of this case, the petitioner Shri Lankeshwar Palita is hereby directed to appear before the investigating officer of Goremari PS case number 75/2023 and cooperate in the investigation. Stop. Within 10 days from the date of its order. Stop. If he does so within the stipulated period, can be allowed to go on interim bail of 30,000 with one surety of like subject to the arresting authority with following order. Number 1. Let this case be listed again. 5th of January.
Hello, Lordship.
Then
May I please proceed? Lordship, the petitioner, the informant are, my lord, doing the same business of the same lifting work, and some well took place, my lord, out of which might be alleged that by thou I have stabbed him. My lord, injury caused, out of which my lord, my name is also in the FIR. Page 17 the FIR. Lordship has already granted the co-accused bail, interim protection. The date speaks on 22/12 for 3D.
Who assaulted with thou?
My lord, my name is dear Bubul Setia. Actually, no doubt, my lord, the name is not properly mentioned. I am Joyanto Setia, Bulbul Setia.
Anyway, my lord, that is not the issue. Issue is that, my lord, prima facie it shows it's a case of 325, my lord. In order to attract 326, my lord, there must be ingredient of 320, my lord. Emasculation, so my lord, my lord, my lord, these no meters are there. Lord, see what I'm saying, my lord, it's a business cycle, my lord. Now, my lord, that going to place, my lord, no doubt, my lord. Out of which, my lord, it is realized that I have given some step or whatever, my lord. Therefore, my
No,
state,
no, let us peruse the
CD, Lord.
injury report,
But only thing, my statement is supposed to come, investigation will be completed, my lord. Reason behind is that because one co-accused, Lordship can see page 19, Lordship has already granted the co-accused bail.
because he,
No doubt.
against him, the allegation was
Absolutely. What I'm saying, my lord, Lordship, sometimes, my lord, this kind of cases is possible to, my lord, complete the investigation when the all statement will be recorded, my lord. Suppose that informant statement is there, suppose co-accused also, only my will be remain, my lord, incomplete. What I'm suggesting, my lord, that let my statement be recorded. It will become, my lord, if suppose there is a revelation of, my lord, that 326, definitely my bail will be go, my lord, protection will be go. But at this moment, my lord, suppose if I will not be appear, my lord, the city will come with incomplete information, my lord. Because I have to tell the story that what actually happened there, man.
no, there
Lordship,
is
as far
other
as-
possibility
yes,
also.
the role of the
Suppose
present
the-
petitioner in the alleged crime, that is, might not be in the same thing with the other
Yes,
co-accused,
that-
because there is a,
We have to peruse the
he has been
case.
specifically named.
No, Lordship, what I'm saying, my
No
lord,
interim.
Lordship,
Why?
this-
Otherwise, in grievous injury cases, there are instances.
Lordship know it well, my lord. If somebody wants, my lord, grievous can be converted in simple heart, and simple heart can be converted grievous heart. No doubt, city will reveal the whole story. At this moment, Lordship, what I'm saying with all respect, my lord, Lordship, it's not that I'm a stranger or I'm not a local resident, my lord. There cruel took place between two same businessmen of some dispute of their business issues, my lord. Here, my lord, if suppose my statement would come, my lord, then it will not, my lord, hamper the investigation, my lord. I'm trying to, my lord, reveal the actual fact that what happens with that particular incident, my lord. So therefore, my lord, at this moment, my only humble submission that if suppose my statement would come, then it will reveal the entire story very clear, my lord. And thereafter, my lord, if medical report, my lord, they tell the whole story that whether there is a possibility of 326 or not, my lord. But at this moment, if I would be treated, my lord, under the purview of 326, my lord, and prima facie, Lordship kindly say, Lordship, may I read the 320 for a moment?
Yes.
Lordship, 320 indicates the following kinds of heart only are designated as grievous. Emasculation, permanent privations of the sight of the other eyes are, my lord, these are the none of the matters, my lord, seems available on the.
What else is there? 320.
My lord, 326, my lord, Lordship, it's a matter of interpretation. 324, my lord, heart with grievous, my lord, weapon, and grievous heart with, my lord, weapons, my lord. There's a true distinction, my lord. Lordship, can you see that prima facie, suppose it shows that if any ingredients comes under the purview of 320, my lord, then, my lord, I'm not entitled to get any protection. Here it just said, no doubt, my lord, some injury took place, my lord, that step I have put, my lord, it all things.
Considering the serious nature of it,
Lordship.
it may be true, may not be true.
Quite,
That
quite right, my lord. Only humble prayer, my lord. If suppose a co-accused already would be supposed within the part of
he
incident.
is on a different.
Yes,
Let us call for the case. Already it is fixed.
the similar
Let
matter is fixed on 20 to 12.
22 is already, my lord.
Heard Mr. S. Chamaria, learned counsel for the petition. Also heard Miss S. H. Bora, learned additional public prosecutor. Considering the nature of allegations leveled against the present petitioner in the FIR, the perusal of case diary would be necessary for consideration of instant bail. Hence call for the case diary. Fixing 22 to
Lord.
Can it be fixed along with another AB, my lord?
along with let this
AB
let
number,
this
my
case
lord,
be listed along with
3965
AB number 3965 slash
2000.
23
Right.
on 22/12/2020.
49 of the supplement.
And right? Company. 49. India, India,
In this case, your lordship, the infraction was what?
Lordship, yes, yes, sir. I've got the instruction. Here it is said they don't need the truck anymore for further investigation. Lordship, you can see this. I have one copy signed by them.
Heard Mr. A.M. Khan, and counsel for the petition. also heard Ms. S. S. Jahan as the additional public prosecutor. This application under section 401/397 of the Code of Procedure, 1973, has been filed by the petitioner for 373, read with section 482 of the same code, has been filed by the petitioner in the Muhammad Ilyas Khan, whereby the order dated 27/9/2023, passed by learned additional sessions judge within the FTC number 3, Kamrup Metro, Guwahati, in NDPS case number 150/2020, whereby the Jimma prayer of the present petitioner seeking Jimma of seized vehicle, that is a truck bearing registration number MN019937, was rejected. The impugn order dated 27/9/2023 is here quoted herein below. Quoted here. Since when it is lying?
Is lying since 16/3/2020.
Learned counsel,
16/3,
learned counsel,
22 ne 23,
22.
22,
22.
22, because the FIR
16/3/2022. Yes.
yes, six-wheeler truck, it was seized on 17/3/22, 16/3/22.
Lying. Where it is lying?
The police station perhaps. It is in police station itself.
In the custody of Sonapur police since 16/2/2020.
3/22.
16/3/2022. Stop. Learned counsel for the petitioner has submitted that the seized truck was the only source of livelihood of the present petition. What else is your submission?
My submission is that the seized truck was run by the apprehended accused person on the basis of the authorization letter, Your Honor.
And he was not aware
Yeah.
of the fact that the seized truck has been used in commission of the offense by the person to whom it was given on rent. Learned counsel for the petitioner has also submitted that no purpose would be served by keeping the seized truck under the open sky in the police station. Stop. When he is ready to produce the seized truck during trial as and when required by learned trial. On the other hand, learned additional public prosecutor who was requested to obtain instruction from investigating officer as to whether the seized truck is further required for any other purpose or not. He has submitted a report from the concerned from the officer in charge of Sonapur police station, who has submitted that the seized truck was used for carrying the commercial quantity of contraband which were seized, and it were the said contraband were hidden by making separate chamber in the thief's trap. And it is further submitted by learned additional public prosecutor that though the seized truck is no longer required for the purpose of investigation, however, it may have to be produced before the learned trial court during the trial, as it is one of the main evidence in the trial pending before, which is the case is pending at the trial stage.
Yes, yeah. Right now, evidence is your lordship before
Pending before the court of learned additional session judge FTC number 3, Kamrup. I have considered the submission made by learned counsel for both the sides, and also have gone through the materials available for including the report furnished by the investigating officer, report furnished by the officer in charge of police station, Sonapur, in Sundar Bhai Ambalal Desai versus State of
Gujarat.
Gujarat, reported in. You have citation?
Yes.
210 SCC. 210
Reported in
SCC.
so and so.
Yes, yes, Sundar Bhai.
Honorable Apex Court has observed as follows.
210 hai.
Court, I'll give the quote from the judge.
210 SCC.
It also appears from
210 SCC. 283.
it also appears from that the seized truck has been lying in the Sonapur police station under the open sky since last how many?
Around 2 years. I mean,
Since
With effect from
No, no, no.
16/3/2020.
at 1 year, 8 months.
since last 1 year, 8 months. And it also appears that the prayer for Jimma was rejected by the learned trial court only on the mainly on the basis of the objection submitted by the investigating officer. However, it appears that if the seized truck is kept under open sky during the entire period of the truck may get damaged or it may become unuseful. Hence, and the purpose of production of the seized truck, if required, may be obtained, may be achieved by imposing conditions on the petitioner at the time of allowing the Jimma petition. Now, what should we do? We should
In fact, Lordship can leave it to them to impose
that-
conditions like bond photographs and all those. As per
in
Ambarlal.
view of above, the this criminal revision petition is thereby allowed and the impugn order is thereby set aside, and the learned trial court is directed to give the Jimma of the seized truck to the present petitioner by
Imposing necessary condition as provided
executing by the petitioner executing a bond of rupees.
It
what
depends
is
on
the
the
cost?
insurance. Kiman ase?
What is the cost?
Cost kiman? Insurance se diya na?
Is
This
your
is
truck
a-
here
This
10
is-
lakhs, right?
by by furnishing a bond of rupees 10 lakh, 10 lakhs, and
The 10 lakh means, your lordship, it will be the cost of the truck here.
Truck is for.
that may have to, suppose the trial court ultimately decide to confiscate it.
Yes.
If ultimately if it decides,
Mm.
then bond of rupees 10 lakh with an undertaking to produce the
Six-wheeler.
said truck before the trial court if and when so required by learned trial. At the time of furnishing the bond, the with whose custody the truck is present, the officer in
At
charge,
present, your lordship, the truck is now in police station here.
the officer in charge of Sonapur police station would take the photographs of the truck from various angles and also make an inventory of the truck, describing the make an inventory of this truck in the said bond. The next is the learned trial court may add additional condition while while giving Jimma of the truck to the present petitioner with above observation this criminal revision petition. I'll make streamline the condition.
As provided
Alright.
in Ambala.
Ambala.
50,
Made clear. It's an application for recall of NPWA and PNA issued against the petitioner, lordship. Impugn order is at page 41, your lordship. Annexure there, lordship. Can I go to
Yes, what has happened?
lordship? Impugn order is at page 41. On that particular test, lordship, the learned the engaged counsel could not take a step. Therefore, NPW has been issued against the petitioner. And our next-
Otherwise, you were appearing.
Lordship, otherwise, I have been taking steps the last 3 occasions, lordship. And lordship, the next step is fixed on
What is your name?
lordship Pallab Gogoi Deuri allies Pallab, lordship. The next date is fixed on Monday for API, lordship. Some protection, lordship. This Monday, lordship. I will appear in invest,
On Monday you appear.
lordship.
Lord. Till then, that NBW may be kept in efforts.
Heard Mr. P.
Keyboard.
P. Bordol, the net counsel for petitioner, also heard Mr. Miss S.H. Bora. Itu আগৰ case. Earlier case. Miss S.H. Bora, the net additional purpose. This application was Code of Criminal Procedure, 1973, has been filed by the petitioner Shri Gogoi Deuri, alias Pallab Deuri, alias Rajkumar Deuri, impugning the order dated 29/8/2023 and subsequent order passed by the additional session judge FTC Lakhimpur, not Lakhimpur, in special NDPS case number 18/2023, whereby non-bailable warrant of arrest were issued against the present petition. Learned counsel for the petitioner has submitted that the petitioner is facing a trial before learned additional session judge FTC within bracket FTC Lakhimpur, North Lakhimpur, in special NDPS case number 18/2023, and on 29/8/2023, the petitioner could not appear. Why you could not appear?
Lordship, the case counsel could not take care of the part
And why you could not appear?
due to medical reasons.
Could not appear for the trial court due to medical reasons. Though it is further submitted that though the petitioner had engaged a counsel to defend him before the learned trial court, however, due to communication gap, the engaged counsel also failed to appear before the learned trial court on 29/8/23. As a result of which, learned trial court issued non-bailable warrant of arrest against the person. Learned counsel for the petitioner has submitted that the petitioner is ready to face trial and ready to cooperate in his trial. It is further submitted that the next date of the case is fixed on 4th of December, and he is ready to appear before the trial court on 4th of December. However, he seeks some protection in the meanwhile as pending non-bailable warrant of arrest.
NPWA.
And
As-
PNA lordship.
As non-bailable warrant of arrest has already been issued against him.
And PNA was also issued subsequently lordship, that is on 31/10/2020.
It is further submitted that the learned trial court also issued orders for proclaiming him as the responder and attachment of his property on 31/10/2020. Learned additional public prosecutor does not oppose the prayer on the base on the ground that the petitioner is if the petitioner is ready to
It's a-
appear before the trial court and face trial, and interim protection may be granted. Considering the submissions made by the counsel for parties, this criminal petition is hereby disposed of with a direction to the petitioner Gogoi Deuri alias Pallab alias Rajkumar Deuri to appear before learned trial court, that is the Court of Learned Additional Sessions Judge within bracket FTC Kamrup, North Lakhimpur on 4/12/2023, and to facilitate his appearance before the learned trial court, the pending warrant of non-bailable warrant of arrest and the operation of pending non-bailable warrant of arrest issued against the petitioner, as well as PNA issued against him, shall be kept in abeyance
Till the next
till
date.
the next date fixed. That is what.
Obliged.
During administration,
Yes.
The 439 application lordship. The petitioner was arrested on 12/10/23. Here, what happened lordship? There was a dispute with regard to a way lordship. A land dispute is there lordship, and the land belonging to one Zakir Hussain was used by this petitioner and their family members lordship for as a way lordship for going to their residences, which was barricaded by the informant side lordship. And on 7/9 lordship, both the parties lordship, they entered into a fight. And unfortunately lordship, both sides sustained injuries lordship. This petitioner also he sustained injuries on his right hand lordship. There was dislocation of his right hand, and one of the members from the informant side died.
Oh.
Subsequently 302 was added. He is already in custody for last 50 days lordship.
50 days.
Yes, co-accused has already been released lordship on the length of detention. And moreover lordship, the medical
What is your name?
Jainuddin is name in the FIR lordship.
Zainuddin.
Yes. Other-
Zainuddin has been released.
No,
Who
no,
has been
lordship, released is nominally is released. lordship.
nominally is was released, Lordship. Yes, nominally. No, this petitioner, that the person who was released, he is the son of this petitioner. And
Yes.
There are otherwise there are material against him. He is the person who has inflicted the injury with the bamboo, and it's a vital part of the body in his head. It is there.
Lordship may come to page 19, Lordship. He attacked him, Lordship, and both sides, Lordship, because if both sides there was a
Right.
attack, Lordship. And on 19, Lordship, page 19, that is the injury sustained by this petitioner, Lordship. Dislocation of his right ankle.
Otherwise, what is the progress of?
Progress, the arrest, some of the accused person, Lordship. Not all the accused persons are not yet arrested, Lordship. And one injured witness, Haidul Islam, Lordship, his statement also recorded. So he has also implicated him.
Who has not been arrested? Fakaruddin.
Fakhruddin and Ainuddin.
Yes,
They are yet to be arrested.
yes, Fakaruddin and Ainuddin.
And Lordship may come to the page 20, Lordship.
No, apart from the arrest, because even if you don't arrest,
My lord,
you can
postmortem,
proceed with the investigation. and
investigation, my lord, statement of witnesses recorded, including the injured person, Lordship. Postmortem report has been collected.
and he has
That is the
been
progress of the investigation.
there. Whether his detention would be required. He's there for 50 days.
There are material against him, Lordship. That I'll humbly submit.
Some medical attention is also
Because he is the
required for
person who
this,
was assaulted.
because he has also gone to Patna, Lordship, and he has taken treatment. So
When have you gone to Patna?
there after that, Lordship, on the
After
I have
that-
annexed, Lordship, that is
Before your arrest.
before your arrest, Lordship, and subsequently when he came back, he was arrested, Lordship. I have annexed that at 21, Lordship, page 21.
Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Zainuddin, who has been detained behind the bars since 9/9/2023, within bracket for last 50 days, in connection with Dolgaon PS case number 315/2023 under section 447/294/326/34 of the Indian Penal Code, with added section 302 of the Indian Penal. The accusation against the present petitioner is that on 7/9/2023, one Khairul Islam had lodged an FIR before the officer in charge of Dolgaon Police Station, naming 5 numbers of accused persons in the FIR, including the present petitioner, inter alia, alleging that on that day, that is on 7/9/2023, at about 1:30 p.m., the accused persons named in the FIR came to the land of the informant to construct a road there And when the first informant restrained them from doing so, the accused persons named in the FIR assaulted the brother of the first informant and the paternal uncle of the first informant, causing grievous injuries on the paternal uncle of the first informant, namely Mahuruddin. Learned counsel for the petitioner submits that there was a dispute between the family members of the petitioner as well as family members of the first informant over right of way over the land of the first informant. And on 7/9/2023, there was an altercation between both the sides over that issue, in which both the sides sustained injury. However, unfortunately, Mahuruddin succumbed to injury. Mahuruddin,
Yes, Lord.
unfortunately, Mahuruddin succumbed to injury. It is further submitted by learned counsel for the petitioner that the petitioner also sustained grievous injuries on his leg,
On his right hand.
on his right hand, for which he had to obtain treatment at Patna, and immediately after the incident, he went to Patna for his treatment. It is only after when he came back from obtaining preliminary treatment, he was arrested. Learned counsel for the petitioner also submits that the petitioner has been detained behind the bar for last 50 days and he is in need of medical treatment, further medical treatment. It is further submitted that in the meanwhile, one of the co-accused, namely Mamin Ali, has been granted bail by a coordinate bench of this court in bail application number 4101/. On the other hand, learned additional public prosecutor has produced the case diary of Dolgaon PS case number 315/2023 and has opposed the grant of bail to the present petitioner on the ground that there are incriminating material against present petition, as he was the person who assaulted the deceased with a bamboo lathi on the vital part of its body, that is head. It is further submitted by the additional prosecutor that two of the co-accused are yet to be arrested, and hence, if at this stage the petitioner is allowed to go on bail, it would hamper the arrest of the remaining co-accused. However, he fairly submits that in the meanwhile, the statement of witnesses have been recorded and injury report collect
Yes, injury report collect and also postmortem report.
and the investigating officer has collected the injury report as well as submission of this. I have considered submission made by learned counsel for both the sides and have perused the material on record, including the case diary of Gurgaon PS case number 315/2023. Though it appears from the materials on record that there are incriminating material against the present petitioner case diary. However, considering the fact that the present petitioner was also injured. And what injury you sustained?
It has a dislocation of his right elbow.
And he also sustained dislocation of his right hand incident. And he has already been detained behind the bar for last 50 days. And also considering the fact that the meanwhile the investigation has fairly progressed. Therefore, merely because of the fact that two of the co-accused are not arrested may not be a reason for continued detention of the present petitioner if their custodial detention is not otherwise necessary for fair completion. Which fair completion. For the reasons mentioned above, the petitioner, namely
Zainul.
Zainuddin, is hereby allowed to go on bail of rupees 30,000 with 150 of like amount, subject to the satisfaction of learned
CGM Sorrow.
Chief Judicial Magistrate Dorong. Following condition. Number one, with above observation, this bail application thereby.
Now,
Taking
like
2 minutes.
Based on the merit lottery.
Yes.
Based on the above information, NACA checking was placed immediately on 7/10/2023 at 4 p.m. SI Kamal Sokia with staff Azara PS with conducted NACA checking and Rani Gate. And during the time of NACA checking, detained one vehicle, number so Wagner, and apprehended, namely Sri Deposit Theory and one Priyanka Das, seized the vehicle and so and 2 numbers of phone and tablet from the possession of the brought of the Azra for interrogation. On the same day at evening, searched the rented house of Minara Begum and Priyanka Das, located at Jyotikushi, Thapalia and Patasi Lambari and Kamrup Metro. And Priyanka Das and Deposit Theory was seized and Viman 500 number note and note inside the on-site white one system box and manufacturing of apprehended and interrogated the Deposit Theory and Priyanka Das. During the interrogation, they revealed that the names of the person. And my lord, another one thing, lordship, finally come to page number 17, the seizure list. Page number 17, type 2. And I and other peers do hereby charge the rented house Miss Minara Begum and Priyanka Das, situated at Jyotikushi, Tapalia, as a laid and shown by the apprehended Priyanka. Very important line. Laid by the Priyanka Das and situated Priyanka Das, apprehended. In this case, I am a professional driver and commercial vehicle, and Priyanka Das is police laid by Priyanka Das and some money is recovered.
You also,
That
that is
the language of police lordship. Otherwise, lordship, that because I was in the vehicle.
your plea is that you are only the driver.
Lordship, yes. Only the driver.
And nothing has been seized from your
My
possession.
position. So,
Anything else?
And lordship, 53 days in custody, lordship. And what purpose will be served? And that time is in the hand of police lordship.
Well, today we have not received the case diary, lordship, but we have received information, lordship, that IO could not produce the case diary today, lordship. So may I pray that the matter will come up on 5th of December, lordship, to produce the case diary.
Honorable court, lordship.
5th of December.
Otherwise, lordship,
Otherwise,
53 days, nothing any involvement at all.
On that day, my lord, if Siri doesn't come, Lordship, may my lord consider it, my lord. Bail application on the basis of merit.
Heard Mr. F. Counsel for short argue phrase that is very could not be produced by investigating officer who has informed him regarding investigating officer who had given a communication to this effect on an additional purpose and done it for additional purpose place for another day for production. On the other hand, Learned Counsel for the Commission has submitted that the petitioner has been detained behind the bar for last 53 days, though nothing was seized from his. So considering the submission made by the Counsel for the Commission, one more chance given to the prosecution side to let this case be listed again on 5th of October.
If she did not come, then bail shall be considered.
Definitely, Lordship, that I have also made. My lord.
On 5th.
Abla-
18.
May I please the lord?
Yes, there is here.
For 39 bail application, madam, the petitioner was arrested on 6/11. But I'm not named in the affair, my lord. Neither named nor my lord involved in the offense alleged, my lord. And my lord, a good many persons were arrested, my lord, in connection with this case, my lord.
Where is the
And-
affair?
Affair, my lord, should be pleased to see at page 10, my lord. Affair, my lord, is written in English, my lord. I have just typed, my lord. Page 10, my lord.
Stealing of smartphone.
Hmm. 78 numbers. In fact, 4 of them were arrested initially. Thereafter, they kept on arresting more people on the basis of statement given by the accused persons. Now here, as far as this accused person is concerned, his name figured only on 6/11/23. When Ajibur, another accused, he took anticipatory bail and then his statement was recorded. He was initially absconding.
Okay.
Then he took an AB and then his statement recorded. In his statement, he implicated this money rule, saying that he had sold 10 mobile phones to a shop which is run by Monirul and 2 others. And those 2 others were also arrested. They have also said that we were told that new mobiles were available and we bought it.
From the present petition.
From Ajibur, who had an AB and who appeared later and his statement was recorded. In fact,
Now,
his
what
state
is the allegation against the present petitioner?
that he and 2 others were running a shop and they bought 10 mobiles from
Okay.
Ajibur.
Okay. They-
And but whether they are also involved in the entire racket of selling stolen mobile phones, that I think it's not clear because I have seen Ajibur's statement. Ajibur had initially said that I sold few mobile phones to few persons saying that those were stolen. But as far as Monimul, he did not say whether he told them that these were stolen mobile phones. This is, I don't find in Ajibur's statement. I'll read out that Ajibur's statement. Otherwise, his statement is recorded, Monirul's statement.
How many?
Ajibur had said, initially he said,
24 days.
he was arrested only recently, 16/3. Oh, sir, no, 6/11. 6/11. 16/11.
6/11.
Or 6/11. Now, Ajibur's statement, Ajibur said,
No, whether the mobile phones which were recovered,
Hmm.
10 mobile phones, were the stolen mobile
those were stolen mobile phones,
out of these 78.
78. Because when they came to know, when police came to their shop, they
And
said it
his
is their
allegation against him is that he only purchased.
he only purchased. But it said that they were involved in the entire racket,
They habitually use.
habitually purchasing stolen mobile phone.
Okay.
This is the allegation.
What is your
But Ajibar, because Ajibar could have said that I have sold them the stolen mobile phones, but Ajibar, he said he had taken those stolen, he stole the mobile phone. Then he said, Monjurul Loko and Monjurul, these are different people. Then later he said, Tetia Ajibore Kole, Tumi 1 lakh tokar 25টা নতুন seal pack থকা mobile পাবা আৰু বাকি থকা 10টা নতুন মোবাইল আমবাৰীৰ দোকানত থকা মুঠ চিনাকি 3জন বন্ধু their মণিমূল names come মিলি মোবাইল দোকানৰ নাম DIB মোবাইল টকাত মুঠ 52,000 টকাত বিক্ৰী কৰো তাৰ পিছত যোৱা ইমান তাৰিখে because he did not say initially he said তাৰ পিছত মই ৰাধুৰাম বজাৰত গৈ মঞ্জুৰুল ইছলামক লগ পাওঁ these are other accused person মঞ্জুৰুল ইছলামক কওঁ যে মই 1.5 লাখ টকা ধাৰ কৰি কসিমউদ্দিন আৰু নীলাচলৰ নামৰ ব্যক্তিৰ পৰা বহুত কেইটা চুৰি মোবাইল কিনিছো এতিয়া মই মোবাইল কেইটা বিক্ৰী কৰিম Manjurul, he said that from
He is not Manjurul.
I am
no, he is not Manjurul. To Manjurul, he said that I bought so many phones, which were stolen phones from Kasimuddin and Nilchan. তেতিয়া মঞ্জুৰলে কয় যে মই ইমান টকা নাই যদিও 1 লাখ টকা মান দিম মঞ্জুৰুল introduce these three guys to Ajibor.
No, but now the question is whether there is any material to show that they purchased it knowingly that
These materials are
stolen.
not there. Simply forwarding report is there. They are yet to investigate. Otherwise, statement of Ajibor
Now,
is
do you
okay.
need their custodial detention?
No, in fact, his statement was recorded.
Mr. AFNU Planet Council for the also heard Ms. S. Jahan and petition for this application under section 439 of the Code of Criminal Procedure Common 1973 has been filed by Momirul Hassan Mia, who has been detained behind the bar since when?
6/11.
Since 6/11/2023 within bracket for last 24 days in connection with Horolumuk PS case number 225/23 under section 461/380 read with section 413 of the Indian Penal. The accusation in this case that on 25/7/2023, 1 Vikas Nahar, who is the proprietor of Messrs. Krishna Enterprise, lodged and situated at 80 Road, Horolumuk, lodged an FIR before the officer in charge of Horolumuk Police Station, inter alia, alleging that on 25/7/2023, some unknown persons had stolen 78 pieces of smartphones from his shop. And it is also alleged that an amount of rupees 2,300 was also stolen therefore. Learned counsel for the, what is your submission? Learned counsel.
I submitted that, my lord. I am not involved with this.
Learned counsel for the petitioner has submitted that petitioner is innocent and he is not involved in the offense which has been alleged in the FIR. On the other hand, an additional prosecutor has produced the case diary of Horolumuk PS case number 225/2020 and has submitted that the investigating officer has recorded the statement of presentation and some witnesses under section 160. It is also submitted by learned additional professor, though there is material on record suggests that the petitioner had purchased 10 numbers of mobile phone along with other from
Ajibar.
one Ajibur who is the co-accused in this case. However,
Ajibar doesn't say that he had
it is
sold.
not clear from the statement of the said Ajibur that
They knew that
the present petitioner knew that
those were stolen.
those
phones.
mobile which he had purchased were stolen. An additional prosecutor has also submitted that otherwise also the petitioner statement has been recorded and he has taken preemptive action. Stop. Considering the submissions made by the counsel for both sides and after perusal of the material from record, including the case diary of Arul Mukti Estate number 225/2023, this court is of considered opinion that as the investigation has fairly progressed and as the statement of the present petitioner has already been recorded, and as at present there is nothing to suggest that the petitioner knowingly purchased the 10 mobile phone. Petitioner purchased the 10 mobile phone knowing them to be stolen from the custodial detention of the further custodial detention of the present petitioner does not appear if he otherwise cooperate. Hence, the petitioner Umirud Hassan is thereby directed is thereby allowed to go on bail of 30,000 with one security of backup to the satisfaction of the
CDM
Chief Judicial State with further petition. The bail application, the instant bail application is accordingly sent by the
Diplomat.
All right.
19,
Yes, my lord. CD was called for him. Received.
Yes.
It arises out of on PS. Yes, my lord. The affair is at page 8. My lord. Regarding seizure of counterfeit currency, my lord.
Since when you are detained behind?
I am detained since 14/10, my lord. I've completed 47 days. My lord, we are not required for police custody, my lord. It's jail custody. Police is not required for interrogate.
Otherwise, what else is your sub?
My lord, we happen to be unfortunately at that place of the at that place in that point of time when the raid took place by the STF, my lord. My lord, we are not connected with this counterfeit currency. Only thing is that we are found in the same premises, my lord. That is why we are not required for police custody.
Yes.
My lord, it is investigated by my lord special task force, my lord. This is a fake currency case, my lord. And my lord,
the fake currency was, my lord, seized along with these, my lord, these petitioners, my lord. They were at the spot, my lord. And my lord, police, my lord, the investigating, my lord, IO, my lord, they have, my lord, at this stage is a crucial stage of investigation, my lord, because, my lord, forensic report is yet to come, my lord, not in the part of the case diary. And my lord, other things, my lord, yes, it is, lordship knows that it is offense against the state, my lord. And some,
All offenses are offenses.
no, my lord, yes, my lord, yes. But it's a 120B is, my lord, inserted. And my lord, it is a direct, my lord, directly affected the, my lord, economy of the state, my lord.
That
And my lord,
no,
so my lord, at
what
least,
materials are there against?
Yes, my lord, they were the, both the petitioners, my lord, the Hafizul and, my lord, the another, my lord, is 20, the Abdul Razak.
Only
They were,
one
my lord,
petitioner is there.
One, there's the another,
19
in item 20 also. The two, these are two people.
Okay, Hafizur and
And Razak,
Abdul Razak, my
Abdul
lord.
Razak.
They were fully involved in the case, my lord. The statement from the witnesses, my lord, recorded so far, my lord. Their involvement is there, my lord, and, my lord, they were seized along with this, my lord, the fake currency and other some materials, my lord. Those were, my lord, used for making the fake currency, my lord. From the spot, and, my lord, all both of them, my lord, are there, my lord. And, my lord, from their statement and from their statement of the other accused also, my lord. And, my lord, the IO has stated that the present petitioner, Hafizul, he was, my lord, connected with some other cases relating to the fake currency. So he is, my lord, habitual in this offense. So as it is, as, my lord, my submission is that, my lord, as it is in, my lord, the forensic is yet to come, report is yet to come, my lord. So at this stage, my lord, if bail is allowed to them, my lord, it will, it is a probability to affect the investigation seriously.
Respectful submission is that we
Because,
cannot
my lord, it is a 90
interfere
days
with the
offense, my lord.
forensic,
And, my lord,
cannot
because
intimidate the forensic team. And we have already there for 47 days. And there's no nothing incriminating has
no,
been
apart from forensic, what else?
my lord, from their statement, my lord, and my statement of my lord,
Apart from, why do you need their custody?
my lord, because police is, my lord, investigating it, my lord, because some more, my lord, materials is, it is a probability that yet to, my lord, is to come, my lord. Because, my lord, it is a organized crime, my lord. Only 4 persons is arrested, my lord. There are so many persons involved in this case, my lord. So many persons, my lord. Because only 4 persons cannot do this type of things, my lord, alone. There are so many persons involved, my lord, as it is organized crime, my lord. So police is investigating, and, my lord, it is a crucial stage of investigation, my lord.
No, let them appear before police station.
So they are appearing, my lord. It is a, my lord, they are in the jail, my lord.
No, they are now in custody,
Yes, my lord.
jail custody.
They are-
If you require them,
Yes, my lord.
let them appear daily before.
If lordship allows, my lord, my objection, and, my lord, the stringent condition,
what condition?
that is, my lord, that the daily, my lord, if required, my lord, they have to
Where do
appear.
you stay?
My lord, we are native of Lakhimpur, my lord, but we have rented accommodation here.
So how will you cooperate in?
Whatever conditions my lord imposes. This is the restriction of my lord. And I am willing to abide by all the conditions imposed by the court. Only consideration, my lord, one major consideration is that I was not even required for police custody. My lord. Police did not want me for interrogation. They sent me to judicial custody. They paid for judicial custody. Only out of the 5 accused, only 2 were sent to police custody. Only they were required for police.
May I, my lord, one prayer, my lord. May I place the case diary, my lord, before your lordship. Kindly, my lord, have the objection, bail objection of the, my lord, IO, my lord, kindly. And, my lord,
From whose possession the Scorpio vehicle was recovered? From your possession?
No. Nothing was found from my possession. I only happened to be at that premises during the time of the raid.
My lord, seizure list is there, my lord. I have taken my.
No, one of the main objection is you have to find out other members of their gang.
Yes, my lord. It is.
Third, Mr. R. Sharma. Learned senior counsel assisted by Mr. E. Ahmed.
Yeah.
And counsel for the petition. Also heard Mr. D. Sharma and additional professional. This application under section 439 of the Code of Political Command has been filed by the Commissioner Hafizur Rahman, who has been detained behind the bar since 14/10/2023 for last 47 days in connection with Hatigao PS case number 335/2023 under section 120B/4 511/420/489/489B of the Indian Penal Code. The gist of accusation in this case against the present petitioner is that on 13/10/2023, one Mukut Basha, Inspector of Police, lodged an FIR before the officer in charge of Hatigao Police Station, Inter area, alleging that on receipt of an information through reliable sources, the informant, along with the other members of other police personnel of Hatigao Police Station, raided the premises of whose premises was raided?
My lord, seizure list is there, my lord.
And it is from Muhammad Atikur Rahman, the main accused. Milanpur Hatigao.
Raided the premises of
Muhammad Atikur Rahman.
Muhammad Atikur Rahman, who was suspected to be dealing in fake Indian currency notes and seized some fake Indian currency notes of various and some other materials which is suspected to be used in manufacturing fake Indian currency. From where you were arrested?
No, Hatigao.
No, what is your plea that you were present there?
I was just present there. Me and the second petitioner were just present there. Even in the forwarding report, when the police asked for police custody of only two people, this is the last page 20 of the order. This is an order of the CJM.
JM First Class, I have perused the case diary. On perusal of the case diary, it appears that the accused Atikur Rahman is one of the main mastermind of the commission of alleged offence, to whom fake currency notes are transported to other northeastern states. I am of the opinion that the investigation would not likely to proceed further if accused Atikur Rahman is not interrogated in police custody, as it is revealed from the version of the IO that the many more evidence are yet to be collected. Hence, the petition filed by accused Atikur Rahman is rejected. So only 2 people were asked for police custody.
Learned counsel for petitioner has submitted that petitioner is not involved in the offence alleged against him FIR and he is innocent. It is further submitted by learned counsel for the petitioner that on the date of alleged search operation conducted by the police, he happened to be present in the premises where the raid was conducted, and he was therefore arrested along with other 4 accused persons. However, it is submitted that when the present petitioner was produced before the learned Chief Judicial Magistrate, learned JMFC, learned Judicial Magistrate First Class Kamrup Metro, after their arrest, his police custody was not sought for by the investigating officer. Rather, the investigating officer sought the police custody of one Atikur
And Mizanur.
one
Only 2
Atikur
people.
and Atikur Rahman and Nizam Ali, who were alleged to be the main accused in this case. Learned senior counsel for the petitioner has further submitted that otherwise also the petitioner has completed 47 days behind the bar, and considering the period of his detention, he may be allowed to go on bail. On the other hand, an additional public prosecutor has vehemently opposed the grant of bail to the present petitioner at this stage, on the ground that though the statement of the accused persons who were arrested have been recorded by the investigating, however, there are other members who are involved in the dealings of fake Indian currency note, as this crime is an organized crime. And if at this stage the petitioner is released on bail, the police may get difficulty in apprehending other accused persons who are involved in the offense. What is the specific allegation? What he does?
My lord, they were making the
Some accused person makes, some carry,
yes, my lord.
some are porters, some are
Yes, my lord.
some
They carried, my lord. They carried, my lord. In his statement, my lord, it is clearly revealed that he has carried that bag, my lord.
he only carry.
Yes, my lord, and he knows that it is a fake currency. He is that is not in knowledge, my lord. The statement, my lord, lordship will find at the last tag, my lord. I have flagged my lord. He is about to carry it to Shillong. both of the petitioners.
But he has said that he does not know that these are fake.
If lordship goes to the my lord, other statement, my lord, that will be clear. My lord. Because my lord, they were both the petitioners were called for the tax, my lord, to do. They were called.
Learned counsel for the learned addition for the prosecutor had no what was it? Learned addition for also persons. The present petitioner was engaged by the by the by the group who are involved in the dealings in fake Indian currency note to carry the fake Indian currency note to the to various parts of the to Shillong Stop. I have considered the submission made by the council for both the sides and have perused materials available on record, including the case diary of North Lothian Port PS case number. Sorry, nothing of PS case number 335. It appears that on the date of the seizure itself, 5 accused persons were arrested, out of whom the police sought remand for 2 of the accused and the present petitioner's police remand was not sought for the investigating officer. It also appears that in the meanwhile, the investigation has fairly progressed and it is mainly pending for the receipt of FSL report, forensic laboratory report. Considering the progress made in the investigation and considering the fact that the petitioner has already detained behind the bar in the last 47 days, his further custodial detention does not appear to be necessary if he otherwise cooperate in the investigation with the investigating officer. In view of above, the petitioner Hafizur Rahman thereby allowed to go on bail of 30,000 with 1 security of like amount to the satisfaction of learned Chief Judicial Magistrate Kamrup Metro with following condition that the petitioner shall provide his contact details, including his mobile number, to the investigating officer and shall appear before the investigating officer as and when so required for the sake of fair completion of it. That the petitioner shall not directly or this bail application accordingly sent back.
My lord, one condition, my lord, without prior permission of the my lord,
The petitioner,
will not move to the out of jurisdiction of this.
is it okay? Will you stay in Guwahati or will you go back to Turkey?
May kindly, if my lord deems it fit and proper, then without the permission of the police officer.
My lord.
With the permission of the police officer, he can.
Yes.
One more. The petitioner shall not leave the jurisdiction of the Court of London Chief Judicial Magistrate, Kamrup Metro, without prior leave of the investigating officer of the Attigam PS case number 12. With above observation, the bail application is thereby disposed of. Abdul Razzaq also same.
Same
Same
circumstance.
Same.
Next, item number 20 also same. Change the name of the accused. So petitioner's name will be different. Date of arrest is same.
Same.
And two IAs were filed for correction of that 489 PNC. In the petition, there was a mistake, my lord, typographical error. We had filed two IAs, my lord, for the correction of the same. Instead of 499 B, my lord, it should be 489 C. That is the only.
I has not.
The least one.
It has been numbered, my lord.
I would become interested
My lord, that can be corrected.
because it is not yet. I'm ignoring that.
Obliged.
21,
Idea rejected, madam. I'm not familiar with the length of detention. Today is 63 days, madam. And your lawsuit order is page 25. Okay, it's page 26. P76, madam, that's basically, madam. I mean, two persons, one person was involved up to the lawsuit found, another one is madam. All are measured, madam. If there is anything, it was done with consent, madam. Anyway, I am not on merit now, madam. Whether further custody is required, that much your lawsuit will see, madam. Today is 63 days. And your lawsuit rejected because investigation is yet to be completed and at that stage.
But it is still yet to become.
Yes.
What remains, madam? Guards, madam, statement, everything is recorded. What
No,
remains?
but the nature of offense involved is
So,
very
madam, what remains to be investigated, I am saying, is not a forensic, nor anything else, madam. Only matter whether they need for what purpose, madam. It is not that NDPS, FSL or anything else, madam. Only matter that way I think, madam, your worship may consider. How long they will keep him, madam?
They can keep him up to 90 days notice.
That, of course, I am not denying. That is all there. To tell two accused, it is not that matter somebody remains fine. Both are before lordship. Both are taken the custody.
this is allegations are very.
But the allegation is that she is saying that my lord, she was that person. Actually, there are some relation, my lord. That is admitted. That is, I find from the record.
She was found on road after the.
That my lord, they have stated, my lord, the allegation. Just so much two, number 1 and 2, my lord. Who is his sister's husband? Who what he is to, my lord. Only thing is what he has carried her in a vehicle.
I'm on.
In a vehicle, my lord. His vehicle hired, 2 is also included, my lord. My only paramount is subject of my law, not fiance is my lord. Custody is required for what purpose, if necessary, what for what purpose. Yes, madam, I think it's 3 years old, madam.
No, but on last occasion, the period of detention was considered.
So that was 48 days.
48 days was considered to be long enough.
Madam, no, that was period long enough. Now, when more long has
But
been added,
that
madam.
period of detention was not considered to
So-
be a good ground for
No,
releasing.
normally in this type of case, madam, normally period of detention, that's why second time we have come, madam. 63 days, madam. At best, they can keep me up to 90 days if the statute is submitted. Not more than that, they cannot find. Only the need for what, if they need us, for what, madam. Anything for investigation, what remains fine, what they need us. Already under suspension, this man, madam, already so-called is submitted reply, that also your lordship also mentioned, madam. And in the reply, he has details, he has given the reply, I have annexed it. Earlier it was not annexed, my. The reply also I have given to the department. Number one is one. Number two, last time also, madam, I learned pen was there, madam. Against two, there was no material, otherwise, except helping him.
No, regarding material, my lord, I have nothing to submit because Lordship has already rejected on 14/11/2023, Lordship. Now, Lordship, this is the second bail application, Lordship, and as far the investigation part is concerned, Lordship, my lord, MR has been collected, 164 statement recorded wherein she is implicated, Lordship. It is only pending, my lord, to collect the FSL report, Lordship. Otherwise, my lord, witnesses have been examined, Lordship.
No, you have to show me on what ground subsequent bail application.
Two things, madam. One thing is, madam, so far investigation part is concerned. The lordship mentioned the investigation yet to be completed, madam. If they say that investigation remains, madam. FSL, I do not know what is the FSL here, madam. I don't know what is the FSL here.
FSL, Lordship, it was alleged that, my lord, that she was, my lord, she forcefully consumed some, my lord, some substance, Lordship. For that
Yes,
purpose,
376,
her blood was, my lord, sent for FSL examination, Lordship.
That is not denied, madam. That is admitted one, madam. 376, but taking is admitted, madam. Taking the admitted, madam. So investigation part, second part is at that stage, madam, now 63 days, madam. And I have given a details reply also, madam. There is no question of influencing also, madam. Whatever conditions required, madam. Already they are in custody. Whatever is collected, they have collected, madam. 25 years old girl, madam. But it is not that once time, madam. Continued, no allegation, no complaint, nothing at all, madam, at any point of time. She could have, madam. Brothers filed a case against my lord.
Otherwise, my lord, medical report, nothing has been found, Lordship, because no injury was detected.
That is what I am saying, madam.
That is, as per the medical report, that I am fairly submitting, Lordship, but there are, my lord, allegations of committing, my lord, 376, my lord.
No, that medical aspect was not reflected in earlier order.
No, it is not reflected. Not reflected.
Third, Mr. H.R.H. Chaudhary.
Lordship, Feroz, my lord, this medical report, Lordship.
When she was examined.
Probably, my lord, after 1 day.
FIR is my 18/9.
On 20th, after 1 day.
After 1 day.
Okay, otherwise investigation is almost.
Investigation part, Lordship, what I have seen, my lord, is pending for the FSL report, Lordship, and FSL report was called for, my lord, because there were allegations that, my lord, she was forcefully forced to consume some substance, Lordship. Now, what kind of substance, Lordship, whether it is poison or whether it is some narcotic substance, that we do not know, Lordship. For that purpose, FSL report was, my lord, called for.
Where is the statement of victim?
I have flag mark, Lordship.
I'll go through the statement.
But you also already seen, madam. She has indicated.
I'll again go through it during
But
lunch.
that's up to
I'll
her.
dictate order at 2.
164, she has implicated.
So that
No,
you
there
also
are-
has seen, madam.
There are two accused persons.
Yes.
Regarding
She has-
accused number 2,
She has not implicated.
allegation of rape is not there.
You are paying bail for both.
Both, madam, because already implicated, madam, you also already mentioned. I am not on that now. Now only question is whether they need further requirement. Whether police wanted me further custody.
Okay, let me go.
That is the only thing.
I'll declare order at
Right.
the chamber of
Wait, please, Your Lordship. This is a 439 application, Lordship. FIR is at page 7, Lordship.
This is item number. Yes.
FIR is at page 7, Lordship. Here the allegation is Lordship, the informant while going to the national highway, Lordship, the petitioner and some, along with some 2 person alleged to have snatched away money from him after beating him, Lordship. That is the allegation, Lordship. And main fact of the case is that, Lordship, the petitioner along with 3 person while going through the national highway on his scooty, Lordship, the informant and along with other person who coming from opposite direction knocked the scooty of the petitioner, Lordship. And there was some quarrel took place between them. And after that, the informant lodged this affair. And regarding snatching of Lordship, money, these all are false, Lordship.
Since how many days you are behind?
33 days, Lordship.
When were you arrested?
And 28-10, Lordship. Admittedly, there was an accident, Lordship, and there was a quarrel, Lordship, between the informant.
32 days.
Yes, Lordship. Today, 33 days, Lordship.
Yes.
There are 3 accused persons, all are arrested, Lordship.
And 2 already
Now,
were granted bail.
allegation of snatching money, Lordship, they have, the accused person, they have denied, Lordship. Although there are my allegation that they have also taken my lord money. Now, my lord,
394.
394, my lord.
The robbery in the daylight, Lordship, at around 10:30, 14.
Punishment.
Punishment, Lordship, imprisonment up to life or 10 years up to. But under facts and circumstances, Lordship, the 394 doesn't attract, Lordship. Because although they have made allegation, Lordship, but that is false, Lordship. They have adjudged
394, 90 days offense.
in the daylight, Lordship, at around 10:30, amidst crowd, Lordship, who will choose to commit robbery on the highway, Lordship, amidst crowd. Lordship.
Witnesses said, Lordship, there are some altercation, Lordship, and my lord, some, my lord, assault was there, but they have not sustained any injury, Lordship. That is the, my lord, materials collected during the investigation.
Heard Mr.
P. Haldar, Lordship.
B. Haldar, learned counsel for the petition. Also heard Mr. R.J. who learned additional public prosecutor. This application under section 439 of the Code of Procedure, 1973 has been filed by the petitioner, namely Lucky Burma, who has been detained behind the bar since 27/10/2023 for last, for last 32 days in connection with Vashishtha PS case number
By
657
calculation, 35 days, Lordship.
(35 days) in connection with Vashishtha PS case number 657/20 under section 394/294/294A small 427 of the Indian Penal Code. The gist of accusation against the present petitioner that on 27/10/2023, one Raju Yadav had lodged an FIR before the officer in charge of Vashishtha Police Station, inter alia, alleging that on 27/10/2023 at about 10:30 a.m. when the first informant was going to ATC petrol pump near Vashishtha National Highway Road, 3 boys in an inebriated condition stopped the bike of the first informant and assaulted him and snatched away his 10,000 from the first informant. Learned counsel for the petitioner submits that the allegation leveled against the petitioner in the FIR is not true. It is submitted that in fact the whose bike hit whom?
They knocked the bike of the petitioner, Lordship. Informant.
In fact, the informant had committed an accident by knocking his bike against the bike of the present petitioner on the state day, due to which an altercation ensued between them. However, there was no injury caused to any of the parties, and it is submitted that the allegation of snatching away of his 10,000 of the informant has been falsely made by informant in his FIR. Learned counsel for the petitioner has also submitted that otherwise also the petitioner has already undergone 35 days behind the bar, and considering the period of detention, he may be allowed to go on bail. On the other hand, an additional public prosecutor has produced the case diary of Vashishta PS case number 657/2023 and has submitted that the investigating officer has recorded the statement of relevant witnesses. And from the statement of witnesses, it appears that there was an altercation where both parties assaulted each other. However, no serious injuries were sustained by any of them. It is also submitted by learned additional public prosecutor that apart from the statement of the first informant, at this stage there is no evidence to suggest that no. But though the first informant has implicated the present petitioner for snatching away money from him, however, the present petitioner has denied the same in his statement made under section 164. Learned counsel, learned additional public prosecutor has also submitted that in the meanwhile, all of the three accused persons involved in this case have been arrested. So, considering the progress made in the investigation, as well as considering the period of detention already undergone by the petitioner, his further custodial detention does not appear to be necessary for the sake of fair completion of investigation of the Vashishta PS case number 657/20. So, in view of above, the petitioner, namely Lucky Burman, is hereby allowed to go on bail of 30,000 monthly of like amount to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following condition. Condition number 1. You will not threaten the witness. With this observation, this bail and back the praise for listing this matter on. When do you want?
Lordship, it may be on 5th, I think, any hearing, their Lordship, it may be on 6th or 7th, or it may be on 5th, Lordship. Since it is part at Lordship, at 2, it may be shown as part at, because at 2, then other matters can be finished up, Lordship.
No, it will be again subject to let this matter be listed again on the request of Mr. K. Majumdar, Learned Counsel for let this matter be listed on 5th of December.
December, Lordship. Lordship, please. March July.
Item 21.
Mr. Burwa,
My lord,
what is your submission?
my lord, my submission, lordship is already rejected, lordship. So as far as materials are concerned, lordship, that is already in the case diary, lordship. That is why lordship was rejected earlier. Now, lordship, they have come for a second application, lordship, and today is 63 days. Now, as from the case diary, lordship, what I have submitted, lordship, that investigation, lordship, medical report, 164 statement, witnesses have been examined.
It has been
Only
held-
FSL report is pending, lordship. That is my submission, lordship.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. R.J. Burwa, learned additional public. This application under section 439 of the Code of Criminal Procedure, 1973, has been made by the petitioners, namely Raqibul Ahmed and Ghulam Hussain, alias Ghulam Hussain, who are detained behind the bar since 28/9/2003. It took it last 63 days. Stop. Learned senior counsel for the petitioner has submitted that this is for the second time the present petitioners are approaching this court for bail. Their earlier petition for bail was rejected by this court by order dated 14/11. And considering the period of detention and the progress which might have been made by this time, learned counsel has prayed for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has placed the case diary of the Karabari PS case number 76/23, which was called for in connection with this case, and has submitted that by now the investigation has fairly progressed and the case and it is pending only for collection of FSL report as regards the blood sample of the victim girl, which was sent to FSL forensic laboratory to determine as to what material was administered to her. It is also submitted by learned additional public prosecutor that in the meanwhile, the medical report of the victim girl has also been collected by the investigating officer, which does not show.
That cannot be mentioned.
Okay. Medical report has also already been collected. Stop. Though, stop. I have considered the submissions made by learned counsel for the petitioners as well as an additional public prosecutor. On perusal of the record of this case, it appears that the prayer for bail of the present petitioner was earlier rejected by this court on the ground that the investigation was not completed and the offense involved in this case is heinous in nature. Stop. And 15 days have already been lapsed since the date of that rejection. It appears that in the meanwhile, the investigation has progressed and it is almost complete and only pending for collection of FSL report. It also appears that though there are materials against petitioners in the case diary. However, considering the progress made in the investigation, their further custodial detention may not be necessary if they otherwise cooperate in the investigation and abide by the condition imposed on them while allowing them to go on bail. Stop. For reasons mentioned herein above, both the petitioners named herein before are allowed to go on bail of rupees 50,000 each with with one surety of like amount to the satisfaction of
Lord CTM Borpet.
learned Chief Judicial Magistrate Borpeta with following condition. What conditions?
So accused number one, he is a police personnel, Lordship. So there must be some strict conditions so that, my lord, he will not interfere with the investigation.
Suggest.
So he will not try to, my lord,
General
to
condition would be
influence
there.
the, my lord, investigating officer, and also not to threaten the, my lord, the victim, the family member.
What is he? Home guard?
Home guard, madam. That ABM, APBM. Constantly, he is under suspension or there.
Anyway, my lord, but
Okay.
he is a police personnel, Lordship.
The petitioner shall not directly or indirectly make any inducement, threat, or promise to the victim girl or to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts to the investigating officer or to any police officer or to any court. Number two, the petitioner, after their release on bail, shall appear before the investigator. Will it do?
Yes, my lord.
If necessary, madam.
For 2 weeks you appear?
Yes, for 2 weeks.
Shall appear before the investigating officer of Tarabari PS case number 76/23 for once in every week for 2 weeks or till the investigation is complete, whichever is earlier, and shall cooperate with the investigating officer. With above observation, this bail and by
Lordship, I beg to mention item number 53, Lordship, for upgradation. Just a simple instruction was sought for Lordship yesterday, whether the petitioner has appeared before the IO or not. Verbal instruction was supposed to be taken. 53, Lordship. And that report I have received, Lordship, as per the office bearer. He has appeared before the IO and his further custodial interrogation is not required.
heard Mr. S. Deka, Thanet Counsel for the petitioner. Also heard Ms. S. H. Bora, Thanet Additional Public Prosecutor, who has submitted that in pursuant to the directions of this court, he had spoken to the investigating officer of Gautama PS case number 2/2015, who has informed him that pursuant to the directions of this court, the petitioner had appeared before the investigating officer and has cooperated in the investigation, as well as his further custodial detention is also not necessary. For the completion of the investigation of Gautama PS case number 2/2015. You are not on interim bail, na?
No, yeah.
No.
In view of above, the in view of above, in view of above, it is hereby. No, I have not discussed. Correct. Stop. It is submitted by learned. What was that? On perusal of the record, it appears that Dotoma PS case number 2/2015 was registered on the basis of an FIR which was lodged on where is the FIR?
Lordship,
FIR
at page 30,
38.
4/2/2015.
Lodged on 4/2/2015 by one
Rizaz Patwardhan, zonal manager.
by where is the FIR?
At page 32,
Page
your
30,
lordship.
Lordship.
32, you get.
34 is the relevant page. By the journal manager.
Used
Lordship.
by the journal manager of UCO Bank, Journal Office Bongaigaon, comma, inter alia alleging that certain fraudulent practices were. Who is Dhaneshwar Brahma? Who are you?
He is the accused. Minister Fund. He is a petitioner here.
Fraudulent practices were committed by
Employee of UCO Bank.
the branch head of the UCO Bank, namely Dhaneshwar Brahma, within bracket the present petition. Learned counsel for the petitioner has submitted that earlier that though his earlier bail application filed before this court in the year 2020 was rejected by this court. However, thereafter he had appeared before the investigating officer and had cooperated with the investigation. The submissions made by learned counsel for the petitioner is supported by the submissions made by learned additional public prosecutor, which he is making on the basis of information received from the investigating officer. Considering the facts of this case and the submissions made by learned counsel for both sides, this court is of considered opinion that custodial detention of the petitioner Dhaneshwar Brahma does not appear to be necessary for fair completion of the investigation of Dotoma PS case 2/15. Therefore, in the event of his arrest in connection with the said case, the arresting authority shall allow him to go on bail of 30,000 with one security of like amount to the satisfaction of the arresting authority. With following with above of that with bail of
Highly objected.
22.
May I please, your lordship? On the last occasion, the case diary was.
My lord, here I have received information from our office that my lord, that said Lakhimpur PS, not Lakhimpur PS case number has transferred to the Siemens Sapuri, my lord, police station, my lord.
Oh. What is the case?
Lordship, the FIR starts at page number 15, lordship. The allegation against the petitioner is this, that
You are on interim bail.
I am on interim bail, lordship. However, this honorable court is waiting for the case diary since the month of April, your lordship. Lordship, may kindly peruse order.
You have appeared before the IO.
Appeared or not?
I have appeared before the IO. I have duly cooperated, lordship.
But as per information, my lord, it was office from our office that my lord, it was transferred to Siemens Sapuri.
My lord, may kindly peruse order dated 28/4/2023 of this honorable court, lordship. Where, on the last time the case diary was submitted that day, and this honorable court has observed also that page number 5 of order dated 28/4/2023.
Yes. Yes,
cooperative, their lordship,
please read.
at page number 5, lordship, the court had the court had earlier called for the case diary. Mr. R.R. Kaushik, learned additional public prosecutor, has produced the case diary, which also contains the medical report. The medical report opines that there is no evidence of any injury over her body. Perusal of the medical report also reveals that there was no finding that she was subjected to recent sexual abuse or assault, or that she was pregnant at the time of examination. No injuries on her body were also noticed. Lordship, later on, this honorable court was pleased to grant the interim bail. Interim protection was granted to the petitioner, and lordship since then ultimately on 19th of June, again this matter was fixed for the case diary, and this honorable court has further observed at page number 6, lordship. At page number 6, lordship. This court is of the view that prima facie there appears to be contradictions between the depositions made by the informant before the District and Sessions Court Dhemaji and the statements made in the FIR connected to the present case. The matter is under investigation and the charge sheet has not yet been filed. The statements of the witnesses examined do not implicate the petitioner at the stage of investigation. The investigating officer is directed to expedite the investigation in the matter and take it to its logical conclusion. In the meantime, the court is of the view that the petitioner can be granted interim bail at this stage. Accordingly, in the interim, it is directed that the event of the arrest of the petitioner in connection with the aforementioned case, he shall be released on furnishing a bail bond of so and so, only with two local securities of like amount to the satisfaction of the arresting authority. The bail granted, however, is subject to the following condition. In one of the condition, lordship, a condition number, I will read all the conditions. That the condition number 1, that the petitioner shall appear before the investigating officer within 10 days from today and such other dates as required and
No,
cooperate.
Mr. Sharma, what is your submission?
My lord, today I have no my lord, order also from our office. It is informed that he also taken information from the OC concerned, my lord. It was transferred to the Siemens Sapuri. This is my information at present. Whether he has appeared or CD is earlier received or not, that information is.
And what is the police station case number now?
My lord, now it is not, we have not yet received, my lord. It is from information, it is transferred to.
Then we will make
my
bail absolute in respect of Lakhimpur police station case. In this case, we can make a
not to 105. 105.
It's not a 105, 2000.
Third, Mr.
PP Methi.
PP Methi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, he has been informed by the investigating
From our office, madam. From our office.
From the office of the public prosecutor that who has informed the
OC concern of the madam.
The officer in charge of the Lakhimpur police station has
not Lakhimpur. Not
is
to the office of the
office of the public prosecutor that Lakhimpur PS case number 105/2023 has been transferred to
Siemens Sapuri
police station
Dhemaji.
In Dhemaji district. On the other hand, learned counsel for the petitioner has submitted by order dated 28/4/2023, the petitioner was granted interim anticipatory bail in this case, and in pursuant to the directions of this court, in interim anticipatory bail in North Lakhimpur PS case 105/2023, and in pursuant to the directions of this court, petitioner has appeared for investigating officer and has cooperated in investigating. So, in view of the submissions made by learned counsel for the petitioner, the interim anticipatory bail granted to the present petitioner by order dated 28/4/2023 is hereby made at
My
I'm deeply obliged.
with condition number
lord.
with condition number
My lord.
2, 3, and 4 attached to the said order remaining intact.
My lord.
The above observation is bail application is hereby.
I'm deeply obliged, Lordship.
Three.
My lord, here we have not received a case diary. They are in interim, my lord.
None appears for the petitioner on call. Done an additional public prosecutor prays for another date for producing the case diary. If
Aye.
there is allowed. Let this matter be listed again on
19th, my lord.
19th
19th,
December.
12th, my lord.
The petition, the interim order shall continue till next.
My lord.
85.
Here, my lord, charge sheet submitted, my lord. Charge sheet.
You are on interim bail.
Yes, sir.
You have appeared before the IO after it.
Interim, sir.
Interim, I'm on interim.
Have you appeared before the investigating officer? After. There was, oh, no, there was no such direction. No,
My lord, for the interim, there is not.
no interim is there, but
Interim,
there was only,
I have,
there was a direction that within 10 days you will appear.
I have no knowledge of Lordship.
You take instructions. We are fixing it tomorrow.
Tomorrow, my lord.
Learn Third miss
Are they,
are
On
who learned
behalf of
counsel for the petitioner.
Otherwise, charge sheet submitted.
You seek instruction. Tomorrow we will pass out whether the who prays for some more time for taking instructions from the petitioner as to whether he has appeared before the investigating officer in pursuant to the directions of this court
My lord.
passed by this court on 19/10/2023. The prayer is allowed. Let this case be listed again on 1/12.
Pandit.
26.
Lordship, kindly please, Monday.
On 4th of 12.
My
Lordship.
My lord, CD was called for, my lord, but information is that charge sheet submitted, my lord.
Petitioner is an interim.
All petitioner.
One only, my
128. Item 28. Sorry, my
Heard Mr. H.S.R. S. Das.
My lord, if this matter perhaps RP has not been
my lord.
Whether CD is there.
CD not.
Except 5 others are on interim.
My lord, only one petitioner.
Item number?
Item 26.
Only one petitioner.
No. Item 26, 26.
Oh, sorry.
My lord, CD not received, my lord.
Item 26, there are 5 petitioners.
6 petitioners, my lord. 6 petitioners. Yeah. 20.
Yes.
CD not received.
Heard Mr.
My lord, there is an interim.
What is your name?
Yes, hello.
Heard Mr. H. Talukdar. You are sure that you are in this case? Heard Mr. H. Talukdar. Because name of the council is different. Heard, mi- okay. Heard Mr. H. Talukdar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case that prayer is allowed. Let this matter be listed again on
18, my lord.
18 prayer. The interim order shall continue.
57,
May please, Lord. Court 38 application, my lord. My lord, last August CP was received, my lord, and medical report was called for from Golpara Medical, my lord, regarding the injury, my lord.
Whether medical
My lord, we have received the medical report along with the case there, my lord. Here, medical report shows that, my lord, simple blunt. But there are 3 injuries, my lord, in the victim also said that, my lord, who has assaulted, my lord. It was the petitioner number 2, my lord, Yusuf Ali Mandal, my lord, who has given the blow, my lord. Kukri blow, my lord.
who is on interim?
My lord, petition number 1, my lord.
Now, what is your submission?
My lord, regarding the dispute regarding, my lord, was altercation between petitioner and informant and the petition number 2, my lord, regarding what's the thief, my lord. Thief was left, but subsequently there was alteration. But in fact, my lord,
But they after blow.
but petitioner number 2 and the informant, my lord, there was another dispute regarding their, my lord, Skeldia's car. That ground, my lord, he was implicated. My lord. There is nothing, my lord. Where medical report especially clearly says, my lord, simple injury, my lord.
Okay. The interim order is made absolute.
Right.
And the
Only one interim was only for one, my lord. That is
no, that is made absolute. And the for petitioner number 1, petitioner number 2, he is also allowed to appear before the investigating officer within 10 days.
Hello.
I'll pass orders in chamber.
Hello.
And regarding leftover, you have to pray before.
My lord, whether CD required or not.
CD not required. I have heard your submission.
My lord.
With regard to item 43,
Regarding all leftover matters,
the maternity 14, item 14.
you have to take dates from the court master who will accommodate. In
It has
case,
come
wherever there is an interim interview will continue. If CD has come, CD will be retained till next day.
Can it be on tomorrow, my lord, 35 only? CD has come. Lord, Oblige. Hello, Blanche. Good.